What's wrong with that? If there's something wrong with it, take it to the Congress. But you say we don't know whether it's a day or a month. Why don't we know that? If he or she received a special education, then if it doesn't say of more than a day, seems to me that ends the inquiry. But I really had a question. That's why I started talking. It says receive special education and related services under the authority of a public agency. If we rule against you and say 412A10C applies to this case, are you seeking any refuge in the related services? And what does that provision mean anyway?
Your Honor, I see my time has expired. May I briefly respond?
Please.
Thank you. Your Honor, the term special education does admittedly mean classroom instruction. However, if this court were willing to read those two terms in the disjunctive, as it sometimes is to avoid absurd results, then the related service would include IEP preparation. That term is defined in the statute by a non-exhaustive list of services that include a wide variety of therapies, transportation services, medical services, basically anything that furthers a child's education, special education.
Are you making this argument, by the way?
I'm sorry, Your Honor?
Are you making the argument that even if you don't have previously received special education, that the child has received related services? I just want to know if you're making the argument.
Your Honor, I am arguing that the IEP preparation and the evaluation process is sufficient to satisfy the term related services and that threshold requirement, even if this court reads 1412 as a limit and a change to the substantive law.
So it's your argument that if I go out and hire a consultant and pay a consulting fee to either critique a proposed IEP or come up with one, that satisfies the special services add-on?
No, Your Honor. The service must be provided by or under the authority of a public agency. And here it was the public school district that provided the evaluation and prepared the IEP, which is why that service should satisfy that threshold requirement if this court considers that to be a threshold requirement to this remedy. Thank you.
Thank you very much.
Mr. Chief Justice, and may it please the Court, my name is Daniel Schwei, and I will be arguing the Arlupa issue on behalf of the respondent. My colleague, Allison Ryman, will be arguing the IDEA issue. Together, we are asking that this Court affirm the judgment of the 14th Circuit. Your Honors, this case is about whether Congress can confer a tremendous benefit on only religious organizations. The benefit at issue here, namely Arlupa, allows religious organizations to challenge local government zoning decisions by hauling the local zoning board into federal court and forcing that zoning board to justify its decision under the most demanding standard known to constitutional law. The 14th Circuit correctly concluded that Arlupa is unconstitutional for two reasons. First, Arlupa exceeds Congress's powers under Section 5 of the 14th Amendment. Arlupa seeks to implement the exact same compelling governmental interest test as RFRA, which this Court already rejected in the City of Bernie decision. Once again, Congress is not enforcing the 14th Amendment, but is instead usurping this Court.
Counsel, what about the argument that your adversary made that there is a great deal of anecdotal evidence that would demonstrate a basis in which to invoke Article 5 of the 14th Amendment?
Anecdotal evidence is simply not sufficient to justify Section 5 legislation. This Court stated that in the city. Anecdotal
was my word. They said anecdotal and other statistical information. Do you feel that there is a factual foundation that demonstrates violations or a pattern, a large, significant, widespread violation?
No, Your Honor. The factual record here is woefully inadequate to justify a nationwide solution like Arlupa. In the record in Congress, in the House report, there are only 2 examples of adjudicated cases displaying discrimination against religious organizations. One of those cases is Lukumi Babaluai, and another is a Fifth Circuit case from 1988, over 20 years ago. Those are the only two examples of adjudicated religious discrimination.
But didn't your adversary correctly state that we really have to pay great deference to congressional findings? And the Congress said that it was massive evidence. Is it for us to second-guess their description that it's massive? They looked at more, I think, than just the one or two cases. They tried to look at a pattern, not only anecdote, but case law. Your adversary said there was some expert evidence in the record. And aren't we to give great deference to congressional findings?
Certainly, Congress deserves deference. However, that deference is not unlimited. And that goes...
I think the case law says great deference, does it?
The City of Bernie decision, I believe, just simply says
Okay.
deference.
All right.
And that deference is not unlimited, which has been the entire theme of this court's Section 5.
So you basically feel that we should just say that Congress misspoke when it talked about massive. That's our prerogative to say we don't agree that it's massive, even though you've done, as the judge indicates, certain research and studies and whatever they looked at. We have the power to just say, well, that really is not massive.
Absolutely. It is this court's prerogative to protect its duty to interpret the Constitution and define the content of the Constitution. That goes all the way back to Marbury, and it's the core holding of the City of Bernie decision.
So we can look at the congressional record and, as Justice Lippman indicated, reach our own conclusions about the quantum, the value of the evidence that was adduced before Congress in connection with these hearings and testimony and documents and whatnot that were presented.
This court would not be engaged in any sort of open-ended inquiry.
No. So I didn't suggest that. But what you're saying is that we should look at the evidence, and we have no fact-finding ability at all. I mean, in connection with drafting this litigation. That's what Congress does. So Congress holds hearings, commissions studies, does whatever it wants, and reaches a conclusion. And so what you're urging us to do is look at, to the extent we may be able to, whatever Congress looked at, and then overrule their judgment that the evidence was massive.
This court does not need to adopt any sort of fact-finding role. All it has to do is look at the record before Congress and determine whether it is sufficient under the congruent and proportionate.
What's that if it's not a fact-finding rule?
Because this court does not need to affirmatively reach out and determine whether there were other things that Congress could have looked at. It only needs to examine the record.
You're saying it only needs to look at what Congress looked at, the record Congress looked at and said that record's not sufficient.
Precisely, Your Honor.
And you don't think that's a fact-finding rule?
What I mean to suggest is there is no affirmative duty on this court that would go beyond its institutional capacity to reach out and do independent research. However,
But aren't we taking over, or are we taking over the role of the legislature? Is this an intrusion into the legislature's role?
No, Your Honor.
By the judiciary?
And in fact, it's an intrusion that Congress is making upon this court's role. It is the province and duty of this court to define the content of the Constitution, and the conclusion of just giving Congress unbridled discretion